Okay, I'm going to quickly introduce Nick Kennedy he's a community advocate from the Mountain Watershed Association with a background in law. And he's got a lot of information back there on the tables. Nick, just take it away because we're running a little late.
Thank you. This is kind of where it gets boring. I apologize. Travis had the sexy slides and he had all these pictures and things, and I get to do the law, so I apologize if it's kind of boring. But it's very important for a number of reasons that we're going to discuss. Next slide. I'd just like to introduce you to who we are. I work for the Mountain Watershed Association. We're a community-based grassroots organization out of Fayette County, actually in Melcroft. So if you ever drive to Seven Springs, you'll pass our office. We serve primarily Fayette and Westmoreland counties. We do a lot of outreach. Formed around a kitchen table in 1994. Next slide, please. This is our staff. That's me. Next slide. What we do. One of the primary things we do, which is relevant to what we talked about with natural gas, is remediation of numerous abandoned mine discharges resulting from over 125 years of mining. That's important because what Travis said was how the gas companies can just walk away. Well, that's what the coal companies did. And now we're getting millions of dollars, our organization, from the federal government to help reclaim this water to clean up Indian Creek, which has a number of mine discharges into it. To tell you a little bit about myself, I was born and raised in Greensburg, went to Pitt for law school and undergrad, was living in New York City and just recently moved back and became involved in shale development. We help citizen groups around the area through our Marcellus Citizen Stewardship projects. Next slide, please. So let's start out talking about seismic testing. So Travis gave a great overview of the drilling process and the different things that can come up with it. Now it's important to understand what's allowed in your area, what's been agreed to in the parks, and kind of how you can protect yourself. So I'm going to talk about North Huntingdon's ordinance specifically, and this is regarding seismic testing. So they have to get a permit, and the Board of Commissioners has to approve that permit. Once they get an application for an ordinance testing, the township prepares a report to show the areas that could be affected by it. Permits last a year, and under the ordinance they have to get written permission for entering your property. I think that's true even if they didn't put that in the ordinance to make your private property. Next slide. So the tester has to settle all legitimate claims. So if your property is damaged, the ordinance requires them to settle it. Again, I think you would sue them anyways, even if it wasn't the ordinance, but it does require that. This is the notice that's required. So if they're using explosive charges, they have to provide notice to owners of structures within 300 feet of them. So if you're farther away than that, they don't have to provide you direct notice. If they're using the dumper trucks and things like that, then it's 150 feet within that to get the notice. They have to give you notice 10 days before the start, and they also have to put the notice in the trip review. And I have that. Let me exactly what happens with that. You can go to the next slide. Is it 2 weeks?
It was actually set to start on around May 5th, which was yesterday. So it should be starting this week if it hasn't already started. Everybody was having testing.
Yeah, sorry. It's 2 weeks before the application is considered and 2 weeks before drilling's commenced. So testing, they can do it Monday through Friday, 8 a.m. through 7 p.m. and Saturday, 9 a.m. to 7 p.m. No testing on Sunday. They have to restore the property to the condition it was before. That means in terms of digging the hole. They put a performance bond of $100,000, meaning the township could draw that if there is any damage. And there's liability insurance that they have to carry of $1 million per person, $3 million per occurrence, and $1 million for property damage. Next slide. So now I'm going to talk about a pre and post survey, and this is how you can protect yourself. A pre-survey is very important because if your house is damaged, you need to prove what your house was like beforehand. Any court is going to require that. Within the ordinance in North Huntingdon Township itself, the only requirement that they do a pre-survey is for township-owned structures. So for your private property, the gas company, or the seismic company, I'm sorry, is not required to do a pre-survey. Now, I looked at some other ordinances around the state, and they're all over the place, but some ordinances have required that before they do the seismic testing, they have to do a pre-survey of private property, including water testing and well testing as well, which I think is important because of the big risks and the cost as a private landowner yourself. Next slide, please. Do you have the right to refuse seismic testing? It depends. If you've leased your land for oil, for gas, you have to look at your lease. Generally, if I was going to lease my land, you would sign a seismic agreement and you'd sign the gas lease. Usually they're separate things. Some might provide for that. If you haven't leased your land and you own your mineral rights, then it's your choice. Generally, they offer $5 to $25 an acre. It's not the kind of money that you would get for a gas lease. What I would say is if you decide to do that, read the contract thoroughly. Like I said, it should just be for seismic testing. You don't want to sign away your gas rights. They're two different things. And get all promises in writing. Now, if you have what's called a split estate, where you own the surface but not the mineral rights, it gets tricky. You have to look at what your property documents say. I can't be more specific than that, unfortunately. Next slide. So how can you protect yourself? Well, I put on everyone's chairs a Know Your Rights seismic testing guide. And I'll just run through for a few of those things. They're required to have identification, and you should ask for that. That's your right. Again, I'll go back to the pre and post survey. Unfortunately, your ordinance does not require that, so sometimes they do offer that. I said offer a request. You could request that from them, and if you do end up signing a seismic testing agreement with them, you could try to negotiate that into it. Or revise. The group here is looking at all options. So one option could be to revise the ordinance to protect yourselves. And then the next thing I would say is document everything. The pre and post survey are vital to show what your house was like before. If you can't get that, photos, videos, detailed notes of any conversations you had, any promises they made, any changes in your well water you see, and water testing. Again, it can be expensive, but your water can be impacted by seismic testing. And I'm going to get into water testing in more detail regarding drilling and things you should look out for that. But with water testing, I'll also say it's not all about quality of your water, it's about quantity too. That's the thing a lot of people forget is they might not just impact the quality of your water, they might impact the quantity too. That's, people's springs have been damaged and dried out and things like that. And keep copies of everything. The other thing I'll say is communicate sensitive areas to the seismic testing company that comes in. If you know of, I have some examples in my notes, underground mines that they wouldn't know about, if you have a spring on your property, anything like that, it's important to note to them so that they can take into consideration when they're doing the testing. Historic buildings, quarries, abandoned oil and gas wells, things like that. Next slide, please. Now I want to discuss the ordinance in North Huntingdon Township. Gas drilling is allowed in North Huntingdon Township based under Pennsylvania law and then also the ordinance. The township controls the zoning of the drilling. So where is it allowed? It's allowed as a conditional use in most zones within North Huntingdon. Now what a conditional use is, it means that it is a permitted use, it is allowed under the zoning ordinances, but it has to be approved after a hearing. So this would be when they come in to try to drill. There has to be hearing, different than the leasing of the parks. This would be to even on private property. And that, I believe, would be the Board of Commissioners that would be holding that hearing. It's not allowed in zones R1 and R1A. That's specifically excluded from there. And then gas processing and compressors are only allowed within the industrial zones in North Huntingdon Township. Now I want to talk about protected structures. There's a specific definition under the ordinance, and that is protected structures are defined as any residential dwelling unit, commercial, business, school, religious institution, or public building located within 1,000 feet of the surface of the road. then that building is considered a protected structure. Next slide. So as Travis mentioned, site development can't be, it has to be within it can't be closer than 500 feet to a protected structure. Concerns about that? Well, there was just a well explosion recently in Greene County. And around that well, there was a half-a-mile perimeter set up around the site, and Secretary Abruzzo, who's the head of the DEP, viewed it from around 1,500 feet. So if that's your school, if that's your church, that's your house, it's a little scary to be within 500 feet. That's the closest they could put it, but still, pretty close. Now, if you, on your own property, decide to waive that, you can, and you could have it closer. I'm not sure why you would, but to each his own. Other provisions under the oil and gas ordinance. As Travis mentioned, they have to enter into a road protection agreement where they restore the roads. The township has to review the EMS services. They have to determine if they're properly trained, and if not, then they can require the oil and gas company to do a training with them on the well pad, an orientation training. Under the ordinance, they're supposed to take necessary safeguards to ensure dust controls are in place and that offensive odors are not emitted. That's all it says. So I don't know, it's pretty vague. I don't know what they would require, or maybe they don't know. The other thing it says under the ordinance is, to the extent possible, it asks that the gas company take into consideration an individual's enjoyment of their land when they're placing the well. So again, there's not really any teeth behind that, but they also say that the township engineer should also consider that permanent. It's not very specific. Next slide. Site lighting. As Travis mentioned, this is an industrial activity. There's bright lights going 24 hours a day. It can be very obtrusive to your quiet neighborhood. It asks in the ordinance that they direct lighting downward and inward to the extent possible to minimize light leaving the site. That's all it says. So again, there's some things that sound like they could be useful, but there's not much teeth behind them, so I don't know if I have much confidence in them being that enforced. There's no construction between 9 p.m. and 7 a.m. based on the ordinance, but that doesn't count the drilling phase. That's going to go 24/7. And then they also have to provide to the township, the gas company, any environmental impact data, including disposal of hazardous products and what environmental impacts they see in the future from this site. So that's something that you could request of the township. In terms of notice, what kind of notice do they have to provide to landowners in the area? Well, seismic testing was 300 feet. With this, it's landowners 2,500 feet from the well. Next slide. They have to notify you 2 weeks before the activity. They have to let you know the location of the well, the description, general description of what they plan, give you a 24-hour emergency contact, and they have to give their availability for a Q&A session with the local residents. Noise, there are noise regulations in the oil and gas ordinance in North Huntingdon Township. They set maximum decibel levels. Basically, they set a standard of, I believe, 55 as the average during the day and 45 during night. Now, the gas company can come in and do their own measurements and prove that the background noise pre-drilling is higher than that, but that's at their discretion. Now, during, can I get the next slide, please? They are allowed to exceed those decibel levels during the drilling process, up to 10 decibels above that. So it could be up to 65 decibels, I guess, that they're allowed to exceed it. And I read somewhere that the World Health Organization recommends a maximum of 55 decibels per day during the day, and they're allowed to go to 65. So a little concerning. There is a complaint process, and it depends on whether you're in a protected structure, as I defined earlier, or not. So with the complaint process, if you're in a protected structure and you believe the noise is excessive, you notify the township. The township then notifies the company. Within 24 hours of that notification, they have to come out and do monitoring. If it's determined that those levels exceed what the township has set down in the ordinance, then there's a meeting between yourself, the company, and the township. That's for protected structures, so you have to be within 1,000 feet. If you're outside of that, then it's in the township's discretion whether they want to hold this meeting. What's the resolution if the noise is determined to exceed that level? Well, based on information that the company provides and the township's own analysis, they determine if there are measures that they can implement to decrease the noise. And if they determine that those measures don't exist or they aren't practical, then nothing happens. So it'll continue. In terms of violations of the ordinance, it's up to $500 a day. Now there would have to be continued violations, but $500 is the maximum. Next slide. So now I want to get into water. As Travis went into, there's significant concerns about water pollution, whether it be through surface spills or damage to the well casings, things like that. Now, the things I'm going to talk about in this section are especially relevant to people that have well water in the area. It's also good to know if you're on the municipal water, because the municipal water in this area, from what I understand, comes from either the Yauk or the Beaver Run, and they're doing a lot of fracking right along the Beaver Run, so it's good to consider. So, first thing I'm going to talk about is pre-drill testing. Now, as with seismic testing, I said a pre-survey seismic testing survey is very important. Pre-drill testing is important because it sets the baseline. You can say, well, my water had these chemicals in it before you started, and now it has these chemicals after you started. If you don't have that, it's very hard to prove who contaminated your water. Pre-drill testing is not required by the law. What is required by the law is there is a presumption, it's called. And what the presumption says is that if your well is within 2,500 feet of a drill site, and it gets polluted within a year of them completing drilling or stimulating or altering the well, then there's a presumption that oil and gas drilling caused it. Now, it's not a home run, but that is a presumption. Next slide. Because of this presumption, the industry has volunteered oftentimes to do pre-drill testing. So they'll come around if your house is within 2,500 feet of the site, and they'll offer to do testing for you. Now, there are problems with that, but I will say you should allow them to do that. I mean, you are not entitled to the presumption if you deny them access to test your well. So, despite the problems that I say, and you should allow them to do it. I'm just saying don't rely on it. One of the first problems is that there's no set parameters, and what I mean by that is, with oil and gas wells, there are some things that show up over and over again with pollution. It's just kind of standard things that they use either in frac fluid or certain substances that will come up from underground. Well, they're not under the law. The industry isn't required to test for anything specifically, so they can decide what to test for, and they can leave out very important things. So you don't know if they showed up. If they leave out something in the pre-drill and it comes up later, it's going to be hard to prove that they caused it. And they don't disclose their chemicals, so you don't really know what's going in the ground. So they're not required to really test for anything specifically, and they're not required to disclose their chemicals. So what they test for really may not be as much help as necessary, but you should allow it. Our recommendations are to get your own pre-drill test, if at all possible. Now, it is expensive, and I put sheets on everyone's seat that kind of give our instructions and give some certified labs you can consider. But these are some of the things that we recommend as a minimum, bare minimum, for pre-drill testing. And that's pH, total dissolved solids, iron, manganese, sodium, chloride, ethane, and methane. And these are all on the sheet. You could go beyond that. The DEP has a list of more extensive chemicals you can test for, and the price goes up with that. But if you want to be extra careful, you can go beyond that. Penn State also has a list. People kind of differ in terms of what they recommend, but we think these are some of the most important things. Next slide. Also, I'm just going to mention quantity concerns. Before drilling, it's important not to just consider quality, but also quantity, because your well could dry out, and that's going to be really hard to prove. And the presumption does not apply to quantity. Now I want to talk about the problems with the legal presumption. So, as I said, if your well gets polluted within a year and it's within 2,500 feet of oil and gas drilling, then they presume that the company caused it. And it's the DEP that will determine if your well has been impacted. And the issue with that, and there are several issues, but two of them I'll mention tonight are, the DEP has 45 days to make that determination. But I would be shocked if they met that 45 days. It could take much, much longer, and you may never get a determination. And then also, the DEP has their own pre-drill recommendations, what I mentioned. When they come out and test your water, if you're complaining about it being polluted, they might not even test for these. So they may say, well, you should pre-drill test for these things, and when they come out, they've gotten a lot of flack over this for testing for less than what they recommend. So those things could be polluting your well and not even be tested for by the DEP. That's why pre-drill is essential. And then the other issue with the presumption is it could take over a year. As Travis mentioned, it's the water table. This can take a long time to trickle down to your well. So it's not a slam dunk. You need to be vigilant and do your own testing if at all possible. Next slide, please. Now let's get to the North Huntingdon Township lease and talk about what kind of water protections are in there for residents. The first thing I want to say is what is important is this lease was negotiated. There can be no excuse by the Board of Commissioners saying, well, we're restricted under the law in this situation or this situation. When you negotiate a lease on your own land, you can try to get whatever you want under that. So if there's a presumption of 2,500 feet, you can ask for more. If you want to specify the parameters, things like that. You know, there are restrictions under the law, but this is North Huntingdon Township land. It's a private agreement. So excuses about what could have been done under that and being restricted in law, I don't think apply. Next thing I'll say is a disclaimer. Since I'm a lawyer, I like to add disclaimers. I'm in no way endorsing the lease that was signed for the parks, and by pointing out that there are errors in it, I am in no way saying by correcting those errors it would have been a good lease. I'm just pointing out some of the issues that I saw. There's two main sections under the lease that concern water. There's just a general provision that says there has to be compliance with the law, but there's plenty of flaws in the law that I've already mentioned. Then there's a water testing protection area under the lease. So let's see what this water testing protection talks about. It's all focused on water quality. And as it says here, they have to do a pre-drill test at North Huntingdon Township's request prior to spudding the well. And spudding means just starting the drill. Next slide, please. So the testing under this provision in the lease is of domestic water supply prior to drilling a well on the lease premises. So the only testing they'll do is of the domestic water supply. And I don't even know what that means. I don't know what that means. I mean, to me, I guess it would be testing Beaver Run and the Yacht, right? Because that's where if you're on municipal water, that's where your water comes from. The lease is under the parks. The drilling is going to be around here. You're going to be testing in Fayette County under the Yacht and Beaver Run. Doesn't make much sense to me. I don't really know what that's going to prove or how that's going to really help. That's my consideration. And the other thing I would say about that is another note here that I wanted to mention. The other thing I'll say about that is, so they're testing the domestic water supply. I don't even know if North Huntingdon Township could authorize them to go to Beaver Run or the Yacht to test it. I mean, I imagine the Westmoreland Municipal Authority might have something to say about that if they're allowing Huntley to go out there. The next thing I will say is that they have the right to ask for testing prior to the drilling a well on the leased premises. But they're not drilling a well on the leased premises. They're not starting the well, they're starting outside, as they made a lot of effort to point out. So do they have the right ever to request water testing? I don't know. If they do pre-drill test, then there's testing again within 6 months to a year after completion of drilling. If there's a change in the water quality, then they have, or within a year, they test again. And if the water is materially affected, they have to return to pre-drill quality. Next slide, please. What I want to point out is, to you folks on well water, there's no additional protections under the lease. And this all kind of ties into that. They're testing the domestic water supply, whatever that means, maybe Fayette County and Beaver Run. So I don't know how that really helps folks on private water wells. They're not requiring the chemicals to be disclosed, so you're not going to really know what's going into the ground under the parks. They're not specifying what testing parameters have to be used. And there's no testing of surface water in the parks. And what happens after a year when they don't have to test anymore? Those are some of my concerns. Next slide, please. Again, I want to point out that this was negotiable. I want to compare it also, I'm going to compare this to the Allegheny County lease. Again, another disclaimer, I'm not endorsing the Allegheny County lease at all. That is not my intention. I'm just using this to show that you can negotiate additional protections if necessary, but I'm not saying that's a good lease and I'm not endorsing that. In the Allegheny County lease, they provide for surface testing of water in the parks. They have a more established interval testing, 2 years beyond. They expand that legal presumption that I talked about to 3,500 for 2,500 feet, and they can ask for disclosure of the chemicals. Just some things to consider. Next slide, please. So I just want to conclude and say, why are we talking about this? Why is this so important? And I think another session will be necessary in the future, but there are serious health concerns at risk here. And I have copies of the Shalefield Justice stories in the back, that have real stories about people whose health has been severely impacted by pollution, whether it be air or water, from fracking-related activities. This is definitely serious. It's so serious that, I mean, there needs to be a lot of consideration about what's being done to your community, because in my opinion, the protections just don't exist in the law. As you can see, there's not much protecting you. It's going to be you footing the bill, putting your own dollar out there, arguing with the DEP to try to protect yourself. So I'll give one plug to the Southwest Pennsylvania Environmental Health Project. I think we'd like to have a training with them. It's a nonprofit group. They come in, they can give you air monitors to install in your house. They have medical staff, and they're focused on studying the effects, health effects of shale activities in Western Pennsylvania. They're a very good group, and so hopefully we can get them in here to talk to everyone about that.